Yes. A business method is a collection of related, structured activities or sequence of events that are utilized to achieve a specific product or service for an organization. Business methods can be a software that performs a certain function of the business or even an actual task such as minimizing financial risk. Patentability of business methods is important, particularly for those businesses that offer services as opposed to actual goods or tangible products. Business methods are patentable in Australia, but they are still subject to Section 18 of the Patents Act and the other appropriate common law, the same as all other patent applications. Section 18.1 refers to standard patents, whereas Section 18.1a refers to innovation patents. Both require the same tests be met in order for the patent to be properly granted. Both subsections require that the patent utilise a manner of manufacture in line with the definition in the Statute of Monopolies in order to be successful. In regards to business method patents in Australia, it is the decision made in Grace and the Commissioner of Patents that solidifies the importance of method of manufacture. In this instance, Grant concocted a set of steps in order to protect an asset from an unsecured creditors utilising a trust, a gift, a loan, and a security, and a set of steps that essentially put up a barrier and made it more difficult for unsecured creditors to make a claim on the asset. Grant then applied to have these particular set of steps protected by patent. Upon review, the Deputy Commissioner of Patents revoked Grant's application on the basis that it did not involve a method of manufacture in line with the definition set out in the Statute of Monopolies. Grant, obviously unhappy with this result, decided to appeal this decision to the Federal Court, which was essentially upheld, and then proceeded to appeal again to the full Federal Court, bringing us to this particular case. Justices Heery, Kiefer, and Bennett, in a unanimous decision, upheld the ruling made by the Deputy Commissioner in the previous court, citing the rules laid out in Section 18 of the Patents Act, the NRDC case, as well as other common law from the United States and the United Kingdom. In doing so, it essentially outlined the basis on which business methods are patentable in Australia. For a business method to be patentable, it must involve a physical effect and cannot be a mere scheme, abstract idea, or mere intellectual information. Grant's submission failed to meet Section 18.1a, which outlines that an invention is a patentable invention for the purposes of an innovation patent if the invention, so far as claimed in any claim, is a manner of manufacture within the meaning of Section 6 of the Statute of Monopolies. National Research Development Corporation and the Commissioner of Patents, also known as the NRDC case, outlined the basis on which manufacture is defined in Australian law. In order for something to meet the test of manufacture, it must produce a material advantage and have a new and useful effect that produces a physical effect that can be observed. This is the test set by NRDC for Section 6 of the Statute of Monopolies in Australia. The decision in NRDC stressed the importance of flexibility in the way that manufacture is defined, recognizing that development and inventions are excitingly unpredictable. The court reasoned that Grant's submission did not produce an artificial state of affairs, rather just a mere scheme, in the sense of a concrete, tangible, physical, or observable effect, and hence was not a patentable invention. The court also discussed the history of business methods in regard to intellectual property and confirmed that at 14, business, commercial, and financial schemes as such have never been patentable, in the same way that discovery of a law or principle of nature is not patentable. The court also goes on to clarify that these schemes and laws of nature are still patentable when they serve a mechanical purpose that produces a useful and observable result, and they do not become unpatentable simply because they are for the purpose of carrying out business. This is in line with the decision we reached in Welcome Real Time and Catuity, which confirmed that business methods could in fact be patented in Australia. The court also pointed out that new uses for older voices and other schemes have been refused patents in the past, citing numerous examples. CCOM case is another example the court raised. The decision in the CCOM case was the decision that confirmed that computer software was in fact patentable in Australia. Computer software is a prime example of the way in which business methods can be patented. Whilst it has been established that an abstract idea or mathematical formula is not patentable, it is, however, if the idea has been made into functioning computer software or hardware, as it can be seen to have an observable effect that way. This means if Grant would have built his idea into a computer program, then it would have been patentable. The court also cites applications from Burroughs Corporation as well as International Business Machines Corporation in the United Kingdom and State Street Bank versus Signature Financial Group in the United States, amongst others, as points of similarity as to the patentability of business methods in other similar jurisdictions. Both countries are reluctant to support the notion that abstract ideas alone can be patented without some form of observable effect. Finally, business methods are in fact patentable in Australia, though they are still subject to the same requirements all patents face, namely that the application complies either with Section 18.1 or Section 18.1a and meets the definition of manufacture under Section 6 of the Statute of Monopolies, which goes to show, having a good idea only gets you so far, you have to be able to properly put it into action.